All right, good morning. Last case on our docket today is WEISS versus MSR Partners et al. We have a different panel now joining me here on this third case. Judge Eisnagel to my right, Judge Traver to my left. Again, counsel for the appellant will have, both sides will have 20 minutes. Counsel for the appellant can reserve as much of that as you would like for rebuttal. I will set the default at 5 minutes. If you want something more or less than that, please just let me know. And counsel for Mr. Weiss, if you are ready, you may proceed.
Yes, sir. Good afternoon, Judge Eisnagel, Judge Harris, and Judge Traver. How are you today? Apologies for looking like a stuffed sausage. I forgot my jacket. My dad was kind enough to bring me a new one. So Clarence Thomas, not necessarily my favorite justice, but he has some great quotables. One of them was, bad facts make bad law, odd facts make odd law. And so this is an odd case that's in front of you. It's over the alleged giveaway of a multi-million-dollar business. It was the Lollipop Strip Club over on Grandview Avenue. The facts are undisputed that there was a 3-hour meeting between the parties, Daniel KATZ and Miles Weiss, and that at this meeting, what happened at it is contested, but that it left with Miles Weiss having signed a series of one-page, what purport to be transfer agreements for all of the business assets, the liquor license, terminating the business's 25-year lease agreement, all of the business's cash, intellectual property, and the ongoing operation to Daniel KATZ. The only consideration mentioned in the agreement is a release of a claim for back due rent, which the judge found initially to be sufficient. He filed an amended final judgment following a motion for rehearing it, which we challenged that, ultimately determining that because Mr. Weiss was not a party to the lease and wasn't a personal guarantor, that could not constitute consideration as to him. And if you blink, you'll miss it, but it's paragraphs 83 and forward in the amended final judgment. So what that leaves is to Mr. Weiss in this transfer. The thread this is hanging by is the $10 recital of nominal consideration that's contained in the transfer documents. And so reading Judge Orfinger's final order, what the trial court did is it engaged in, and I mean no offense, but circular logic. It does recite that the law is clear on the issue of what happens when you have a nominal recital of consideration. And what that is the recital of consideration. Usually they'll say $10 for receipt insufficient to hereby acknowledge. It's in every deed that's ever filed. Creates a rebuttable presumption that it was paid. And that, if the party not relying on it, who's challenging it, can rebut that presumption, then at that point, the burden shifts to the party relying on the consideration to come forward with evidence that it was paid. So walking through the logical chain.
But you've asked for rescission here. Rescission
Yes, sir,
being
I have.
an equitable remedy.
Yes, sir.
Lack of consideration is more of a legal claim, isn't it? You can sue for not paying the consideration. You've got a legal claim, so how do you have an equitable relief?
You're not necessarily barred, you just have to pick. You can't have both simultaneously. And so what we would contend is the lack of consideration meant there was no contract at all, or that the contract was voidable. And so rescission would generally be your way to do that because it not only puts the parties back in the position they occupied prior to executing the agreement.
Do you agree you could have sued to enforce the $10 payment?
It was our contention under these facts, no, because our contention is that it was never paid. And so we never had a contract from day one, or the contract was voidable.
Well, the contract says that you get $10, right?
Why
is that not enforceable?
Under the circumstances, Mr. KATZ said he already paid it, and Mr. Weiss said he didn't.
But that's a different issue, right? Let's assume for a moment that your sort of theory of the case is that it was never paid, correct?
Either it wasn't paid or he didn't receive it, correct.
So let's suppose that's our record here, just for the moment. And I understand that that's not necessarily the record we have, but let's assume that the facts are that it wasn't paid. Why can't your client take the contract that says he's supposed to get $10 and sue for breach of contract?
I think that would be a remedy that he would have to elect prior to trial. You can't have both simultaneously. It's not like.
But he could have elected to file a breach of contract, right? Action.
In theory, I suppose he probably could have, yes.
So if you have an available breach of contract action, can you get rescission?
Well, yes, because equity is the only way to put him back in the position he occupied prior to this agreement. The deal was so horribly inequitable. The uncontested Expert testimony at trial is this business was valued at approximately $4.6 million. And so he's alleged to have transferred it for $10 that he, it's completely disputed and unclear as to whether he ever got it, and he says he didn't. And so you default to equity in those circumstances because a breach of contract remedy is wholly inadequate to...
It almost sounds like you're making an unconscionability argument.
We actually, in fact, allege that in the complaint, that the purported consideration was A, not paid, B, if it was unconscionable, and these were the grounds that we alleged for equitable relief. That was pled. And so, the issue that we have is he's given away something of extremely high value for nothing. And, from that basis, we think equitable relief is appropriate. People often plead equitable relief and contract relief, but you have to make an election of remedies prior to trial. And we made the election to proceed as, under the equitable claim of rescission. And we believe that was Mr. Weiss's choice. The fact that he could essentially sue under a contract he claims was never fully formed, yes, he could do that, but that's not his testimony. That wasn't his position.
Well, is not receiving the $10 the same thing as the contract not being formed?
Yes.
Seems like maybe those are two different things.
Well, there's a difference between void and voidable. And in this case, we think that a lack of consideration is what you would have to have at the initial formation of a contract.
But the contract has consideration in it, $10.
Only recites the $10 in the contract. And that just creates a rebuttable presumption that it was paid, which the court found Mr. Weiss rebutted. So on the point of if the consideration was never paid and there was no contract, rescission is the only remedy available to him because it would force Mr. KATZ to return the assets and it would place Mr. KATZ back in the position that he occupied prior to executing the agreement. There's no other remedy at law or at equity that would end in that result.
Because your position is the contract was, there was never any formation of the contract.
Correct. Without consideration, there is no contract. You have one of the fundamental legs missing. You have to have offer acceptance.
But again, there's $10 of consideration stated in the contract, right? But you're saying that because that $10 wasn't actually received,
correct.
That means the contract was never formed at all.
Never fully formed. The assets were transferred by court orders, but the contract itself was never formed. That's correct, Your Honor.
So if that's the case, just a few minutes ago, you said you could have brought a breach of contract action, but under the theory that you just sort of articulated, you actually wouldn't have.
I can sue anybody for anything, I guess, is the answer to that. But under the facts of this case where my client is telling me...
You couldn't have sued for breach of contract.
On these facts, I don't believe so. No, he's claiming that he never got the money and there wasn't a contract to sue on is what this fellow is telling me, which is why I elected this remedy. And so on these facts that I had to go on, that appeared to be the most appropriate remedy. Adding to that is the fact that by court order, these assets were already transferred in a case that, again, this is odd facts, Mr. Weiss was never a party to, but which Mr. KATZ contends adjudicated his ownership interest. So there was a temporary injunctive order issued by Judge Parsons prior to me bringing this case that on an ex parte temporary order on possession turned over.
Can you get rescission on a contract that was never formed?
Well, yes, because the question is whether it was performed. And the contract wasn't necessarily fully
but you don't
formed.
get to performance until formation, right? Usually.
Not usually, but by court order, Mr. KATZ actually went to Judge Parsons on an ex parte motion for a temporary injunction, and ex parte got him to grant this order stating, and actually this is, I will go ahead and state this is not Mr. Spradley, who is Mr. Katz's state court counsel, but it was sort of a sleight of hand. He filed an unlawful detainer action against unknown possessors and Sean Bishop, who is a manager at the business, and then proceeded to get an ex parte temporary order in that case, turning over all the business's assets to Mr. KATZ, and then on the top of that order, he wrote Miles Weiss. As it said, Sean Bishop, Miles Weiss, and unknown possessors. He added the name, which caused me untold amounts of grief in bankruptcy court, and essentially he's run around ever since that time claiming that that was a merits adjudication because it had Miles Weiss's name on it. And it led to one of the most incredible colloquies I've ever had with a bankruptcy judge where I'm like, he wasn't a party, and she's like, but it says it right here. I'm like, well, but he wasn't a party, but it says it right here. Yes, that was added. He was never a party. And so that's what happened. He then ran around with this order that got wrongfully added Miles Weiss's name to the case caption and proceeded to have the business turned over to him. And so he's already got all of the assets. Yes, we contend that there is no valid contract, but the performance has already been made as a result of a temporary injunction order.
Let me get back to the remedy that you've elected. You got this case from the first DCA that's not addressed actually in either brief, but it says very clearly under Florida law, a failure of consideration is not sufficient to support a claim for rescission. Action for damages is the adequate remedy.
Well, in this
Is that case wrongly decided?
In this particular case, I would submit it doesn't fit the facts. Mr. Weiss has, at this point, already lost an operating business. Money damages are not, sufficient to pay him, for what he already had.
How? How are money damages not sufficient to compensate for that sort of damage?
Well, he didn't want the business. He didn't want the money. He alleges that he didn't understand the import of the documents that he signed, and that, he was essentially talked into signing them at this meeting. He did. He wasn't given copies of them. Immediately following the meeting, within an hour, his lawyer and his sons, who are attorneys, were writing to Mr. KATZ saying, whatever my dad signed with you is rescinded. We have no idea. Please give us copies.
But that doesn't answer why money damages wouldn't be sufficient.
Well, at this point, let's state, well, I mean, how do you value this? Strip clubs are a sort of a unique enterprise in that, there's a lot of cash income. It's very difficult to, value them. You essentially value them by bar sales. No bank will finance them. No, the valuation would probably be lower even at the $4.6 million than the business was actually worth. He didn't want to sell it. He wanted to use it as his retirement income. Like for this particular case, it won't replace what he lost just paying him money.
Is there a case in Florida where that holds that a loss of a business cannot be compensated through money damages? I mean, is there any, or is this an issue of sort of a first impression that
No, there's tons of cases on this issue. It's not an issue of first impression at all. It boils down to the uniqueness of the chattel. And in fact, there's history as long as your leg, case law on that exact issue. And if you'd like supplemental briefing, I'm happy to provide it. But if there's a unique chattel involved, then money damages are inappropriate, meaning you can't replace.
And it's your position this is unique chattel?
Absolutely unique chattel, for a variety of reasons. One is it's very difficult to actually open a new strip club in Volusia County. You have to have had a building that predated the current zoning code, which was enacted 20 years ago. The only new one that's opened lately has been Grandview Live, and that's because it was in a building
Don't
that's been
experts
abandoned.
value businesses all the time, right? They look at past income and project income into the future and value the business.
Well, yes, but that's not necessarily the issue here. The issue here is, could he take the money that he was paid in this case and buy that business again? And the answer to that is, could he replace it? And the answer is no. No, he can't. The only place he could
He could replace the money, though,
yeah, but he didn't want
through money damages, right?
Money damages would be insufficient because you can't take that money and replace what you've lost. It was unique chattel.
So under that theory, virtually, what wouldn't be unique chattel under that theory?
A car. Let's say I have a BMW 5 Series. There's 20,000 of them imported to the U.S. every year. Yeah, I may have loved that car, but if I can go out and buy another 540i, that's not unique chattel. For example, let's say I had which I do. As an example, I have a 1984 Rolls Royce with 30,000 miles on it. It's a silver spur that I've restored. There's one like it.
But if you've customized it, then it's unique chattel?
Yeah, or
money
if
damages won't suffice?
Or if I've restored it and I can't find a car of that condition in the marketplace, or there's other reasons why other cars are less valuable or not as desirable, then that constitutes unique chattel. And so in this particular case, that club was extremely desirable. It was grandfathered in and had an unrestricted 4COP license because it dated back so long, prior to the current zoning code and prior to the current alcohol service code. You cannot replace that. It also had a reputation that had been generated since 1999. It made top 10 strip clubs.
The purpose of the business was to make money, correct?
It is. It made top 10
But
strip clubs.
you can replace the money with money damages, right?
Yeah, but you can't replace the business. It's not about giving him money. It's
The business generates money,
Yes, it does.
and you can replace the money with money damages, correct?
Well, yeah, you can always replace money with money.
Sure.
But you can't replace the business with it. The question in this particular case on a rescission analysis is, can you take that money and buy that business again? Not that same one, but one similar to it enough that it doesn't constitute unique chattel. And in this particular case, you cannot. That strip club made top 10 strip clubs in the U.S. in Men's Health 5 years running. It had a stellar reputation. And so, no, it is not replaceable chattel. It was by far the premier one in this area from here, the Space Coast to Jacksonville. It was widely known for that. You cannot replace that club. You cannot replace the reputation. You cannot get into the same location where it was because of the current alcohol service and zoning codes. You would have to be out by the airport, for example, where Mr. Katz's other strip club, Softails, is located. The city has carved out this area where you're allowed to put them. You cannot replace that. So we would contend it's unique chattel that would support rescission, despite the availability of a $10 remedy if you're going to find that that was sufficient, and I'll respect your decision if you do, obviously. You still can't take whatever the money is that he's given, even if it was $20 million, and replace that business. You can't buy it, is what I'm trying to say.
The action at law has to provide him an adequate remedy, not his preferred remedy. I mean, why isn't, as Judge Eisnagel was saying, why isn't money damages an adequate remedy?
Because you
Might
can't,
not be what he wants, but
you can't take that money and replace that business.
you said that's his retirement, so money could be his retirement.
Well, it's true, but you still can't replace that business. The legal analysis is, can you replace what was lost with money damages? So where we're really at on this is you would have to show, to bar rescission, that it was not unique, that it was not a unique item. And it is. We would submit it is. I mean, all businesses are unique to some extent, but if the business can be replaced by going down the road and opening up another one, then it's not a unique item. If a business is so unique based on its reputation, its history, its zoning, its everything else, my light just changed. I'd like to reserve 5 minutes for rebuttal, but I would submit this business constituted such unique chattel that rescission is appropriate.
Thank you.
Good morning, Your Honors. My name is Scott W. Spradley, and I represent the appellees in this case. I believe there are two issues really on appeal. One of them is the legal sufficiency of the $10 nominal consideration. And I believe counsel started down the chain of analysis by the trial court, but I'd like to go forward with that in a moment. Secondly, the issue of rescission. And I think I'll start with that because we only get to rescission if we come out a certain way on the analysis of the $10 consideration. But the trial court correctly found that there's no legal basis for rescission to begin with. That's where the trial court started. The trial court went on to say that even if there were, that Mr. Weiss would not be entitled, in this case, to a remedy of rescission. And what Judge Orfinger found and his basis for that, which is located at record 1511, 1512 through 1518, was that what wasn't stated by counsel was the day after this hearing that was discussed in front of Judge Parsons, in which Mr. Weiss was present and testified, and his counsel was present. That day, after Judge Parsons ruled on a temporary basis that Mr. KATZ, my client, owned the business, Mr. Weiss, with counsel, went and filed a bankruptcy case and put the business in bankruptcy, which led to its closing because it was filed as a Chapter 7 bankruptcy, and the Chapter 7 bankruptcy trustee closed the business. Ultimately, Mr. KATZ was able to get that bankruptcy case dismissed and get his business. But by then, damages were done. And that's where Judge Orfinger said, basically, that because of Mr. Weiss's own inequitable conduct by undertaking a course of conduct intended to damage, if not destroy, the business, he's not entitled to the remedy of rescission. So that's at R1515, 1516, and 1517. And I think Judge Orfinger...
Appellant argues that they were entitled to return of the destroyed business.
Excuse me?
Well, appellant argues that they could receive back, that Mr. KATZ would be in the same position before the deal. He had no business, and the now destroyed business could be returned to appellant, and your client would be in the same position. That's the appellant's argument.
That argument leaves out a pretty substantial fact.
Well, tell us about that.
That fact is, and I'll locate the record site to that there was a liquor license that was encumbered by a lien that Mr. KATZ paid off after he finally got possession of the business. And I want to say it was approximately $100,000 that he paid off for that lien. So it would have been impossible for the characterization that Mr. KATZ started with nothing and then giving him the business back would bring back the status quo is simply not correct.
Because he wouldn't get his $100,000 back.
Correct. So you have that, and as I'll conclude on the rescission part of this with the comment by Judge Orfinger at R1517, which is that he who seeks equity must do equity. And so the concern there was about what Mr. Weiss did to the business after receiving the ruling from Judge Parsons that it was owned by Mr. KATZ. As far as the nominal consideration, the analysis used by Judge Orfinger to find that the consideration was adequate was a correct analysis. Judge Orfinger found that there is a lawful basis for nominal consideration, and the cases have been cited to that effect. That creates a rebuttable presumption, and that Mr. Weiss bears the burden of proving lack of consideration and must come forward with some evidence rebutting it. Now, what is indicated in the initial brief here is that Judge Orfinger erred in finding that there was consideration because alleged testimony of Mr. KATZ that he wasn't sure if he did pay or that he made a joke about paying, but that leaves out part of the testimony, and that's not what the testimony was. In fact, I would call the court's attention to, bear with me one moment, R1514, which is the amended final judgments being appealed in a footnote, and it reads as follows. Weiss states on page 9 of his post-hearing memorandum, document 194, that, quote, in reality, KATZ testified that he doesn't know whether or not Weiss got $10, while Weiss testified that he never received any money, close quote. Weiss refers here to KATZ's testimony before Judge Parsons in the unlawful detainer action, in which KATZ testified that he gave Weiss $10, but did not know whether Weiss picked it up. In KATZ's cross-examination in the trial of the instant case, Weiss's counsel asked KATZ whether he had ever paid Weiss any money, and KATZ testified, yes, I gave him $10, and there's a citation to that transcript. He also acknowledged that Weiss refuted that fact and that he was therefore the only witness to the exchange. In both instances, however, KATZ testified that he tendered the $10 to Weiss. At that point, Judge Orfinger concluded that the burden was properly upon Weiss to show that there was no consideration, but that he had conflicting testimony. Therefore, Weiss did not meet the burden of preponderance of the evidence to show that there was no consideration. So with that, Judge Orfinger found that there was consideration, made a correct ruling, and thus the whole issue of rescission doesn't even come up. So with that, Your Honors, if you have any questions, I've completed my presentation.
Okay, thank you.
Thank you very much.
That leaves out some substantial facts to use the rest of my time. The first is that at trial in this case, by stipulation of the parties, the transcript of the testimony at the injunction hearing in the unlawful detainer action was not used as a rebuttal or as impeachment evidence as you would a deposition transcript. By stipulation of the parties, it was entered into evidence and accepted into evidence as an exhibit. Therefore, it is part of the trial record. This was brought to Judge Orfinger's attention, and we've actually cited the verbatim quote in our brief and provided the record citation for when we say that when asked, Daniel KATZ said he didn't know if Weiss got the money or not. It is in our initial brief, and I would ask Your Honors to look to the record citation contained within the brief, because that did happen. The verbatim quote was, I asked him, did you pay Weiss the $10? And he stated he didn't know. He put it on a table and doesn't know whether Weiss picked it up or not. And then he did, reminding me there was another sentence after that where he's like, I think I even made a joke about it, is the verbatim recitation of that testimony. At trial, he did come back in this case, and I said, well, did you pay him the $10? And he said, well, yes, I did. And so that did happen. But there's a conflict in his testimony. The prior transcript is already an evidentiary exhibit in this trial, and that should have been addressed.
How does that conflict?
Well, he says he doesn't know if he got it the first time. I put it on a table.
Oh, he says he didn't know if he picked it up.
Correct.
Seems like those are two different things.
Yeah, he tendered it, and either version, he tendered the $10.
If I owe you $10 and I put it on the table in front of you, how is that not paying the $10? Now, you can choose to abandon it, I suppose.
Well, it's a little more detailed than that. The notary, Lynn Ken, is Biff Ellis' significant other, nice lady, eminently credible. No reason to doubt her testimony. who was there for the signing of the documents. I asked her, did you see Mr. Katz give Mr. Weiss any money? She said no. Admittedly, there were parts, I'm assuming that they had this meeting where she wasn't in the room, but at the time when the money would have changed hands at the signing of the document, she was there.
But that's a historic fact that this court's not equipped to decide based upon conflicting evidence, right, in the record?
No, well, all I'm trying to show is that the evidence was equipoise at the trial as to whether or not the consideration was paid. You have the testimony of the notary that she didn't see it change hands. You have Weiss's testimony that he never got it. You have Katz's testimony. Once he said, yes, I gave it to him. The other time he said, I put it on a table and I don't know if he got it. So
I don't know if he picked it up.
I don't know if he picked it up.
Right.
But paying the table is not.
So was the fact finder not, based upon that conflict in the evidence, not able to determine that the $10 was indeed paid?
No.
Why
Judge
not?
Orfinger, because it really was equipoise, and that's the word he used.
Because it was what?
Equipoise. I'm quoting that out of Judge Orfinger's final judgment. He said the evidence at trial was equipoise. And then he goes on and he says, however, all of that being said, the court places great weight on the fact that the recital of $10 was contained in the contract. And that's really one of the main problems that we have with it. And he said the recital in the contract persuades me that it was paid. And so that's really.
Did he make specific findings as to credibility between these two parties?
Not really on that
More
issue.
believable?
He just basically recited the testimony. He said it was equipoise and then said that he still finds that it was paid because it was recited in the agreement. And that's mainly the issue I have with the logic chain here, is that the law is abundantly clear that all a recital of consideration or an agreement does is give you a rebuttable presumption. He made an express finding that it was rebutted. He made an express finding that the evidence was equipoise. He then went back to the agreement that all of the law that he accurately recites states only creates a rebuttable presumption, and then used that same agreement, elevated it to a weight that it did not under the law have, and then used that to decide the issue. And so, I have two issues with that. One is he said the fact that it was in there persuades him, and two, the fact that it was contained only in one half of the agreement and not in the other page persuaded him somehow. And so I would direct your attention to the law of construction of contracts. To the extent that there's a latent or a patent ambiguity, that has to be construed against Mr. Katz, not Mr. Weiss. And that's construing it against Mr. Weiss. Katz was the drafter. That's an undisputed fact. He typed these agreements.
This wasn't a boilerplate agreement, wasn't it? It was a
No, it's
negotiated agreement between the two parties, right?
That's a dispute, and they were the only two parties to most of the meeting, really. So, that was he said, she said, but it's undisputed that Katz typed the agreement.
So is the rule whoever types the agreement?
Whoever drafts it?
Even if it's not boilerplate? If both parties have negotiated it out, then whichever party types it up?
I don't know that there's like a boilerplate exception to the rule of the drafter has the contract construed.
Well, I'm trying to find out if the rule is whoever types it up.
The rule is
that's
whoever
what you
drafts
said.
it, whoever writes it, whoever puts the words into it.
But it seems like the record has at least some evidence that it was negotiated by both parties here.
That's what Mr. Katz alleges. Mr. Weiss denies that.
And then one party would obviously have to type it up.
Well,
So
yes.
you think the rule should be whoever types it up?
Yeah, whoever drafts the agreement. That's exactly correct. Yes, sir. And so, as one last, I guess, final, as to how could Mr. Weiss not notice this, when I first came in here today. Well, did you take it off the table? You moron. I just put $20 right here. My Gil can't pick it up. Whatever. You ruined my joke. All right. So, never mind. We would ask the court to find at this point that paying the table is not the same thing as paying Mr. Weiss. When you go through daily life, be it buying a $1 soda at Walgreens or buying a car or buying a movie to watch on Apple TV, any transaction of any sort that you engage in, the person receives your money and you get a receipt for it. And this is different.
Your time is up, counsel.
All right, thank you, counsel.
We're in recess.